Hey everybody, it's Amali Cabral from Common Sense Inc. You can catch us at www.cslawinfo.us. It's www.cslawinfo.us. If anybody's curious, we're a law coaching business, which basically means we're people that assist others learn how to acquire and to cultivate their constitutional rights so that they can exercise them by representing themselves confidently in a court of law. Today's information package is called the Codes. This is one of my favorite packages because it's full of great info about the difference between the UCC or the Universal Commercial Codes and the USC, the United States Codes. Okay, a lot of people get the UCC and the USC mixed up. They think they're similar and they're not. They're two totally different things. The Uniform Commercial Codes are the laws, or the uh, quote end quote laws, right? The fictitious laws that are put in place now that are in the United States court system. The United States codes are just interpretations, or basically the the references made before they pass through legislation before they become a law, or quote unquote what we call law today. So you just got to remember that the UCC, or the Uniform Commercial Codes, are the statutory laws that we're dealing with today, which I go into depth in the information package. I'm not going to go into it too deep right here, but these come from maritime laws that deal with shipping and everything. So I go into that if you just get this information package. And the United States codes are basically interpretations, which meaning you got a bunch of people sitting around coming up with interpretations of what they think is the best process to use to make new bills that are going to produce new laws and legislation. Okay, so I'm going to read a case from this package here, so you get a better understanding of what you'll be getting into when you receive your information package. The case is Ulrich versus Butler. Case number 09-7660. It was a civil case attempting to hold the court to limits as defined by the constitutional and statutory law. Here is the U.S. Supreme Court decision. Here are the details. Fasten your seatbelt. In the 11th Judicial District of Illinois' Woodford County, in a civil case, an individual's civil and constitutional rights were denied as the third judge in the case because the first two judges were recused after review by the Judicial Review Board, which basically means they weren't allowed to hear the case. They then did deny the multiple requests to have all proceedings recorded, did state that no motions or petitions as filed by the individual would be heard, and did illegally incarcerate the individual without regard to habeas corpus, and did knowingly ignore Illinois state statutes, and not only violated due process of the law but denied equal protection under the law. So basically they wanted to silence this man, okay? Failure to obtain substantial justice in state courts led to suits being filed in federal court, which is the Supreme Court, under Title 42 United States Code, the USC, Standard 1983. This suit asks for relief of all orders made in violation of the law, that due process of law be allowed, and further issue relief as the court deems appropriate. The federal district judge in the case stated that although the court does not know the details of the case, that a judge performing judicial functions enjoys absolute immunity, and further stated that a jury would not be allowed in the case. The appellate court, without allowing a brief, supported this order. While a judge performing judicial functions may enjoy immunity, denial of constitutional and civil rights are absolutely not a judicial function and conflicts with any definition of a judicial function. So you got to understand this. What it's basically saying is, as soon as the courts started stepping all over this man's constitutional rights, the judges were no longer immune from any type of lawsuits, because you have to keep understanding, even though it's not mentioned in school, even though it's not mentioned in our daily lives, the Constitution, it still applies, no matter what anybody says, because you'll hear a lot of differencing of opinions online, outside where you live. But you got to understand something. I'm reading it right here from a case that you can't step on anybody's constitutional rights in the eyes of the court. And that's exactly what happened. So when the judges did this, they lost their immunity. Okay, so judges are not immune from the Constitution. Okay, so it says responses to denials were motions to reinstate using the constitutional articles as a major guide, along with the judge's oath of office. Remember, I said from another information package, I talked about the oath of office and canons of judicial code of conduct. Okay, the responses also include page after page of case law where both appellate courts and the Supreme Court did hold judges accountable when their knowing and willing actions fell outside the boundaries of their job description. The failure to follow simple guidelines of their post makes the judge's actions no longer judicial action, but an individual act, as the act represents their own prejudices and goals. So let me reiterate that. The failure to follow simple guidelines of their post makes the judge's action no longer a judicial act, but an individual act. Okay, remember that individual act, as the act represents their own prejudices and goals. So the judge is no longer an officer of the court. He now becomes an individual like you and I. You understand? And that's why he's not immune anymore. Case law also states that when a judge acts as a trespasser of the law, when a judge does not follow the law, he then loses subject matter jurisdiction, and the judge's orders are void of no legal force or effect. So you got to understand, this is very important. The whole purpose of getting us into court to extort us of our hard-earned money, right, is the judge, first thing they have to do is establish subject matter jurisdiction. I go more into that in another information package. Subject matter jurisdiction basically means when you go into a court of law, the first thing the judge will ask you is, do you understand the nature and cause of the charges that are brought against you? Or do you understand why you're in front of me today? You got to understand something. Even though you mentally it makes sense and you understand it, you never want to tell them that you understand, because now, do you hear the semantics? You're under the stand. These people that are running the country now are wordsmiths. They love semantics. They are paper people. That's what they push as reality, when in reality it's fiction. So you got to understand that the judge loses their power as soon as they violate the Constitution. I don't care what anybody says, because it's saying right here, according to case law, that a judge loses subject matter jurisdiction and his orders or her orders are void. So if the judge is saying you're in contempt of court for exercising the Constitution, the orders are void and of no legal force or effect. So even if they do arrest you, you could come back with a federal lawsuit, like in this case here. Okay? Let me finish this. It says, in a limited government, a government limited by the Constitution, the violation of a citizen's rights should never be justified due to the overriding government goals or objectives, and that no branch of government be allowed to extend its power beyond its legal limits. The above issues are one of the outstanding reasons why the framers of the Constitution installed trial by jury as the Seventh Amendment. And a government of the people, is it not a threat to our way of life to allow government actors to ignore the guidelines that define their power? Writ of mandamus or mandate. The petitioner must of course satisfy the court that he has the legal right to the performance of the legal duty as distinct from mere discretion of authority. A mandamus is normally issued when an officer or an authority by compulsion of state is required to perform a duty, and that duty, despite demand in writing, has not been performed. In no other case will writ of mandamus issue unless it be to quash an illegal order. Three things a court needs to establish before they can proceed is subject matter jurisdiction. Remember that. The next time you got to go in for a traffic ticket, to answer to a burglary charge, whatever, remember, they have to prove there's a reason why you're there under their authority. Don't just hand it over to them. Talk to you guys later. Remember, research, research, research. Peace.